On January 2, 2013, the Treasury Department announced it was delaying for 1 year the ACA employer and insurer reporting requirements. Treasury had heard from businesses this morning, and I think we have heard from businesses, and I think we have heard this morning that they needed more time to comply. Because it's impractical to implement the mandate without the reporting, enforcement was delayed until 2015. This decision raises 4 issues. First, was it legal? The ACA's employer responsibility provisions do have an effective date of January 1, 2014. The reporting requirements, however, apply, quote, at such time as the Secretary may prescribe. Also, the ACA requires the IRS to assess and collect penalties in the same manner as penalties under Chapter 68 of the Internal Revenue Code, and the IRS frequently abates Chapter 68 penalties. The IRS claims authority under Section 7805 and points to a long history of both Republican and Democratic administrations delaying implementation of tax provisions when time and resource constraints have made immediate implementation impractical. The IRS is relying on its general rulemaking authority, and what the Trapp case said, which is the D.C. Circuit case, which is the leading case in this area, is that when a question rises as to whether an administration can delay enforcement of a law, it is subject to a rule of reason. Where Congress has provided a timetable or other indication, that may supply content, although in the D.C. Circuit and several other circuits, the courts have held that that does not make an absolute requirement. But other things that can be considered are whether it would damage human health and welfare, whether the court should consider the expediting delayed action or other agency activities of a higher and competing priority, in other words, resource constraints, what are the interests that would be prejudiced by the delay. So I think looking at the judicial legal authority here, I think that they do have some room for discretion.